And welcome to the Week 3, Chapter 3 video lecture. In our Chapter 3, we're going to be dealing with state courts. Last week, as you know, we dealt with federal courts, so now we're dealing with the state courts. Remember, we have a dual system. Each court system is maintained and is under the control of a separate sovereign government. So each of our states are separate sovereign governments, and so is the federal government a separate sovereign government. They each have their own court system, they each have their own laws. And they are sometimes have concurrent jurisdiction. Sometimes one or the other of the courts has exclusive jurisdiction over certain kinds of cases. It all depends on which court we're talking about and what exactly the jurisdiction may be of that court. We'll talk more about that here in just a minute. All right, our learning objectives for this chapter first is to outline the 4 layers of a typical court, state court system, and we'll see what those layers are. And we'll describe the types of criminal cases handled by trial courts of limited jurisdiction. And we'll deal with those in terms of state courts of limited jurisdiction. That means that we tend to sometimes, for efficiency, we'll put certain types of cases into certain courts. And we require only that those kind of cases go to those courts. And that's just efficiency. You know, we get judges that are very good at those cases, and the whole system is set up to do work on just those kind of cases, so they become more efficient. And sometimes we need more of criminal courts, for instance, than we need of civil courts. And so we make more of the criminal courts, and we just sort of divvy up the caseload into courts that are most efficient in dealing with it. All right, we're also going to discuss the similarities and differences between justice of the peace courts and municipal courts. In California, we have done away with justice of the peace courts and municipal courts. They've all been unified into a single superior court system, which we'll talk about also in unifying these different courts. But many of the states still have these justice of the peace courts and municipal courts. These are courts within the city limits, and they are funded by different parts of the government, and they will often have different fundings. They will have different kinds of cases that they deal with, not always good. And we'll see that it can bring about a lot of inefficiencies and so on. But we'll talk about that and on the unification of these different kinds of state courts into one type of court, usually called either a superior court or a district court. Okay. Then we're also going to list out 4 primary problems confronting the lower courts in the United States. And we'll go into what those things are and let you see what they are in more detail. Then we're going to identify the types of civil and criminal cases that are filed in trial courts of general jurisdiction. And by general jurisdiction, what we mean by that is state courts are courts of general jurisdiction. That means they can hear pretty much anything that happens within the state. So if it's within their territorial jurisdiction or their subject matter jurisdiction or the personal jurisdiction of the court, if it happens in that way, they can hear it. That's not true of courts of limited jurisdiction. And we have both courts of limited and general jurisdiction within the state. And state courts, as I say, are courts of general jurisdiction, but within the state, we can limit the jurisdiction of certain courts to certain kinds of cases. And when we're dealing with just generally limited jurisdiction courts, we are generally dealing with the federal courts because they are by nature limited in their jurisdiction, because the federal power was limited by the states when they first enacted the United States Constitution, and that is still true. So federal courts still are courts of limited jurisdiction. They can only hear certain kinds of cases and not others. And state courts can hear every kind of case there is that comes out of a state, basically, with a few very, very small exceptions. Okay. We're also going to explain briefly the differences between a state Supreme Court and states with and without an intermediate court of appeals. Typically what we have in most states are the trial courts, often called district courts or superior courts. Then we have the courts of appeal, which is a system of courts of appeal that oversee a certain number of trial courts within the state. And then we have one superior court, or one, in this case it would be a Supreme Court, and that's the court of last resort within the state. And sometimes we have just the trial courts and the Supreme Court. And so in that case, the Supreme Court has to take over the duties of the intermediate courts of appeal, because in every civil and criminal case, you have one right of appeal. In any case filed in a state court, you have one right of appeal. So the only court that can hear that appeal would be the Supreme Court if there is no intermediate courts of appeal to hear them first. Okay. All right, we're also going to list out the key components of the court unification process. We'll use California as an example because it long ago actually took all the justice courts and municipal courts and unified them into one superior court system. We're going to identify how problem-solving courts use therapeutic jurisprudence and handle cases involving that, such as domestic violence courts, drug courts, and mental health courts. We even have Veterans Affairs courts in California for cases that involve veterans, because veterans have a very special set of problems, and there are courts that are set up that can both dispense justice, but it's typically what happens is you get a veteran and they have some sort of criminal case, and they bring the case, if it's appropriate, they bring it into, if it's a non-violent case, for instance, they bring it into these veteran courts, and the veteran is often given an opportunity to have their case dismissed if they will go through a therapeutic course of action that is overseen by the court. And the court can, if they mess up during the process and don't do what they're supposed to do, they can be put in jail until they're ready to get out and do the program like they're supposed to. And essentially the court sort of forces them through the process, gives them good incentives to want to go through the therapeutic methodologies that'll make them better people. And we think we end up getting better people out of this in exchange for giving up on the criminal case. Often these are cases that may be petty theft cases, something that's not a big deal necessarily. They don't allow it for violence cases. If you're violent, they don't allow you in these kinds of therapeutic courts. But now, of course, there is domestic violence, but domestic violence can be of a low grade, and it can be sort of solvable at the low end, not so solvable at the high end. And so they'll have to, go through the process of filtering to decide which of domestic violence cases can go into a therapeutic situation rather than a punitive situation. We're also going to discuss the consequences of court organization, specifically on court unification. Okay. All right, let's look at the history of state courts. First, there were the colonial courts because, again, before we had the United States of America, we had colonies. These colonies were then essentially territories of England, but they operated as separate sovereign governments. There was the Republic of Connecticut, the Republic of Rhode Island, the Republic of Virginia, all these 13 colonies, and they had their own courts, each and every one of them. They were on the English system, obviously, and they were often did some things that were not so nice, and that ended up being a good example of what we did not want in our court system. So, for instance, they could try you as many times as they wanted to until they could finally get a verdict of guilty on you as a way of harassing people they didn't like. They could hold you pretty much indefinitely before a trial. There was no right to a speedy trial. You could be forced to testify against yourself. You could be, all these things that we've since done away with were going on in these colonial courts. So they were, this is a very, very primitive area of justice back then, and no difference in the colonial courts. And then we had the early American courts, where now we have these, Bill of Rights, and the courts have to start scrupulously honoring these rights of people. You can't be forced to testify against yourself. You have a right to a speedy trial. All these sorts of things start coming in. And so we get the first American courts now dealing with that issue. Now, of course, in a modernizing society, we find that the biggest issue that makes the biggest difference, really, between the early American courts and the modern courts now is that modern courts have just way too many cases to handle. Way too many. Early American courts, that was not so true. People were very spread out back then. It was unusual for people to step on each other's toes, and only a few cases were coming into the courts. Now, in these urban areas where the people are coming together and live, literally feet from each other, and a whole bunch of controversies come up. People are stepping on each other's toes all the time just by their proximity to each other, if nothing else. Lots of different new crimes have taken place that weren't even in existence back then. All sorts of new stuff is coming up. The court system essentially has not really expanded with the population of the United States in state courts, and so now you've got a logjam of cases. that just really causes some real problems. All right, let's look at trial courts of limited jurisdiction. The first level are the lower courts that we're talking about, again, state courts. We're not dealing with federal courts now. So this is, in essence, what's happened here when we deal with these kind of courts is that the state is limiting the jurisdiction of certain courts. Even though state courts by themselves have general jurisdiction, they will take cases that come in and divvy them up into these specialized courts. So for instance, you may have small claims courts. You may have traffic courts. You may have non-felony criminal case courts where they don't hear felonies, they hear only misdemeanors. You may have any of a number. You may have family law courts where they hear only domestic type matters, civil matters. There are 880 trial courts of limited jurisdiction in the United States. 27,179 judicial officers. I'm sure that has changed since we see this being printed on a PowerPoint. They make up about 85% of all judicial bodies in the United States. So you can see that only a small percentage of the cases that are in the United States, let's say 15%, are at the federal level. The rest are all done in the state court, and done in some of them, many of them in limited jurisdiction courts, but also some of them in the general jurisdiction courts. Okay, but there's more than 62 million cases per year. The majority of cases are traffic cases. That's 39 million. Typically, these lower courts can authorize search warrants. They can handle early stages of felony cases, such as doing probable cause hearings, commonly known as preliminary hearings, where the court decides on whether there's sufficient evidence to hold someone over for a felony trial, but they will not do the felony trial. Then only the general jurisdiction courts will hear those. Two types of non-felony cases. There are misdemeanor violations. That's something where you can go to jail for up to a year, and then ordinance violations that typically have fines only, and typically non-criminal type ordinance violations. Let's say you might just be given a fine, but it's a civil fine rather than a criminal fine. But ordinance violations could be either criminal or non-criminal. All right, courts' controversy in reducing crime. So let's ask this question: should the DUI and distracted driving prosecutions be increased? Well, we know distracted driving kills people. We found out that driving distracted will be as bad or worse than driving DUI. And so we're getting a lot of people being maimed, killed, and otherwise having their lives destroyed as a result of someone just texting while driving, for instance, and or driving with under the influence of alcohol or other drugs and causing all these accidents. So the question comes out: should there be more or tougher punishments for DUI, or is the current amount of punishment sufficient? That's a difficult question because it seems like no matter how much the punishment is for DUI, there's always going to be another DUI. For instance, a news item just came up recently in my local area in Central California, where a sheriff's deputy was just picked up for DUI. And you'd think, wow, they would be smart enough to know not to do that. But no, even sheriff's deputies are doing it. Were there punishments enough to get him, in this case, to stop doing it? No, they weren't. These punishments are pretty heavy, most of which are not just fines, not just possible jail time, but also your insurance rates go through the roof if you want any kind of insurance. That's your real financial loss for a DUI. Then the question comes up: should more efforts be made to arrest and prosecute impaired drivers, or is the current level about right? Very difficult question to answer. Obviously, we have too many DUIs. We do a step up enforcement during times when we know there'll be more people driving under the influence, such as New Year's Day and Christmas, and a few of the other holidays like July 4th, that sort of thing. But is it enough? That's a difficult question to answer. What should be done about drivers who operate vehicles while distracted by their cell phones or texting? What do we do with them? They have killed many, many people, and they are more dangerous than the DUI driver, according to most studies that have come out recently. What do we do about that? That's a serious question. There's not very much in the way of penalties, not compared to DUI, but they're as dangerous or more dangerous. Overall, then, how do we punish? How do we do punishment and enforcement levels of DUI and distracted driving? How do these compare with other social problems, such as domestic violence and drug abuse? What do we do about those things? Difficult questions. As you can see, there's lots of controversy involved in these questions, and the courts are right in the middle of it. For instance, it's well known among judges that if you want to keep, especially where you're elected as a judge, this is a state court where all judges are elected. First, they may be appointed, but they end up having to stand for election after so many years. They want to keep their position. Well, the worst thing that they can do is do the criminal courts, because if someone's going to get killed or hurt because of a decision you make, it'll be in the criminal courts. Because let's say you didn't put somebody away that you could have, you reduced bail when you shouldn't have on somebody and they got out and killed somebody. That's when you're going to be on the front page of the paper, and that's when you're going to lose your position at the next election. And so judges don't like doing criminal cases for that reason. You can always make what you think is the right decision. People don't like it when they find out someone got killed because you could have done something better. All right, the small claims court, the maximum ranges anywhere from $2,500 to $25,000. In California, it's $10,000. So you can take some pretty big cases into small claims court, and they do not allow lawyers in small claims court in California. They typically have a lot of landlord-tenant disputes, but they can also have debt collection of all kinds. You could sue for an auto accident case if the amount of damages is low enough. There's also justice of the peace courts. These are we call them justice courts in California. They were often very lower caseloads, such as traffic things. A few maybe misdemeanor cases that would come into them. These were things that happened within certain geographical areas. For instance, they would take over those very small caseloads and do those from the point of view. It's called a justice court because they so-called dispense justice rather than worried so much about the law. But in reality, they were just another law enforcement court. It's just that they were limited jurisdiction by the number or kinds of cases that they were receiving. Municipal courts are just courts within cities, and they're usually funded by the city, and that creates a real problem because the funding is not uniform. You could have a city that's very poor, and they will not do a very good job of funding the court system, and because of that, you'll get much less justice for your dollar, so to speak. But typically, it's an assembly line justice kind of situation. We have a courtroom work group, which we'll talk about more in another lesson on that. But the courtroom work group is the judge, the prosecutor, and the defense attorney when it comes to criminal cases, and how they work together to deal with cases is kind of interesting. But they typically end up settling without a trial 95% of those cases. If it weren't for that, courts would almost immediately stop working because they would not be able to try all the cases that are involved. Municipal courts also do sentencing in criminal cases, but typically municipal court cases will only try cases of misdemeanor varieties, not felonies. Although they, in some cases, they will do what we call probable cause hearings on felony cases. They will do essentially the preliminary hearing, and then if there's sufficient probable cause that's been established, they'll send it off to the Superior Court for a trial, felony trial. Some of the problems with lower courts are inadequate financing, inadequate facilities, lax court proceedings, and unbalanced caseload. So, for instance, they may not be able to afford a transcriptionist for their proceedings, so they will tape record them, and that causes lots of problems. First, tape records pick up things they shouldn't. Sometimes they'll pick up conversations between a defense attorney and their client that were whispered, and they can hear it. Sometimes the recordings are just not working, and the entire record is gone. It'll never be able to be found again because it doesn't exist. Those kind of things that could really cause you some grief if you were trying to appeal the case and you had no record of what happened in the proceedings. Very interesting. There's also alternative dispute resolution processes that go on in civil cases, by the way. They don't do this in criminal cases. The so-called community justice issue, the alternative dispute resolution process involves arbitration and mediation. Arbitration is a situation where you essentially substitute an arbiter to come in and decide your case. It's sort of a rent-a-judge kind of situation, but it's much cheaper than the court system, and you do it in private so that the record is not made public. It doesn't have to be open to the public, as would be true in a public trial. You get a decision. If it's binding arbitration, then that decision is binding on you. You cannot go into the court system and set it aside and go to court. If it's non-binding, then it's just sort of a suggestion on how the case should be decided. Mediation is where we get the two parties together to talk, and a mediator comes in to try to sort of get them to voluntarily agree to resolve the matter without a trial. It often helps that there's a mediator, because sometimes the parties just can't see a way to resolving it because they hate each other, and the mediator can often make things work because they sort of take that element out of it, and they can see it from an objective point of view. Community courts, these are typically midtown community courts of New York City is one example. These are set up, again, limited jurisdiction courts to hear civil cases and small matters of one sort or another. Okay, let's look at some questions that we might have about lower courts. First of all, of the different types of lower courts, which ones exist where you live? You might want to look that up. You want to look for things like, is there a juvenile court? Is there a family law court? Is there a small claims court? Is there a municipal court? Is there a justice court? Is there, there could be a whole bunch of them. Is there a drug court? Is there a veterans court? Is there a domestic violence court or a mental health court? These are all types of limited jurisdiction courts. Then the next question is, would you prefer a different type of court in your area? The question is, do you think that a different kind of court could help in your area? Do you have a certain kind of societal problem that you have? For instance, maybe you're next to an army base and there's lots of veterans around. Many of them are homeless. They end up committing crimes of kind of a low nature, but often are kind of difficult to deal with. They're often mentally ill. Often they will not seek treatment. And if the court system might essentially sort of nicely force them into getting some treatment for their mental illness and help them to do better as human beings. What's your opinion on the community justice? Is that a good idea to have community justice courts where maybe we don't even have lawyers as judges, but just people from the community who come in and hear cases like that, but have the same power as if they were from the regular judge? So take a look at Midtown Community Court of New York. Once you get an idea of what it's all about, then let's hear your opinion maybe about what you think its effectiveness is in general. All right, let's look at some of the trial courts of general jurisdiction. These are the major trial courts. In California, we call these the superior courts. And again, in California, everything is a superior court now because we've unified all the courts. But they are courts of general jurisdiction. That means they can hear any case about anything that happens within the territorial jurisdiction of the state of California, or is within the subject matter jurisdiction of the state of California, or involves personal jurisdiction over someone that California has personal jurisdiction over. Essentially, if California has jurisdiction over the matter involved in a situation, then the trial courts can hear that case. Okay. Geographical jurisdiction, again, is just the political boundaries of the state where we're dealing with state courts. California also involves 3 miles out into the ocean and the islands around that area, as well as the entire actual geographical area of California. It may also involve personal jurisdiction over people who are residents of California. It may also be subject matter, which has to do with everything except a few areas where the federal government has exclusive jurisdiction. So they can hear anything that happens, whether there's a law regarding it or not. And there's sometimes cases where people come in and there's no law that even applies to the situation. No, it's an all-new situation. No one's ever seen it before, or at least not seen it in the court system, and the courts still have to deal with it. There's 3,109 major trial courts in the 50 states. There's 10,740 judges. There's 31.9 million cases per year in the major trial courts. 64 million in state courts generally, but about half of those are in the major trial courts. That's a lot of cases. If you try to divide that out, you'll find out there's a lot of cases for every judge. Criminal cases, state courts typically hear street crime cases. Most criminal cases do not go to trial. 95% or more of those cases are resolved prior to trial. The decision is not guilty or not guilty, but rather what penalty should be applied is sort of what most of the cases that come into the criminal system are involved with, because if the prosecutors are doing their job well, by the way, they're not filing cases that are very marginal. They're filing cases that are very strong. And because of that, the defense attorneys know it's strong, and they know they don't want to touch it, because if they go into trial, they're going to end up getting something pretty high in terms of a penalty, whereas if they can negotiate a guilty plea, they can get something less than what they're likely to get if they go to trial. And so that's why so many of them resolve prior to trial. And so the real decision is not whether they're guilty, but whether the penalty should be this or that. Civil cases, again, they dominate the dockets of most trial courts. There's a lot more civil cases than criminal cases, but criminal cases take priority because of the right to a speedy trial. Most common civil cases are domestic relations, that's family law. Estates, which is like probate, that sort of thing, and then personal injury cases are another one. All right, let's look at some of the major trial courts in different states. First, the circuit courts. Alabama, Arkansas, Florida, Hawaii, Illinois, Indiana, several other states have circuit courts. And there's also courts of common pleas in Ohio and Pennsylvania. These are the major trial courts in these different states. So they call them by different names based on different traditions on what they were called. And therefore, we just usually call them differently. But basically, they are general jurisdictional courts that can hear any case up to and including the major crimes and major civil cases. There are district courts in other states. As Colorado, for instance, use the word district court for the trial courts, for the major trial courts. They use the word superior court in Alaska, Arizona, California, Connecticut, Delaware, and a few other states as well. So you can see they just use different names for the same thing. The major trial courts are named either the circuit courts, courts of common pleas, district courts, or superior courts, but they are all the same thing. They are the major trial courts for the state, whether they're by one name or another. Also, interestingly, in New York, and only in New York, they call their trial courts Supreme Courts, which is really kind of dumb, because it's not really their Supreme Court. It's their trial court. Their Supreme Court is actually given a different name. But that's just New York for you. They had their own traditions, and they decided on those names long ago, and they've kept them since that time. All right, intermediate trial courts of appeal, or excuse me, intermediate courts of appeal. A century ago, there was one court of appeal. And it was a court of last resort. This is a long time ago. Most states now have a series of intermediate appellate courts. So essentially, the Supreme Court was the court of appeals for you. There was only one right of appeal. You only had one court of appeal, and that was it. You were done. If you lost at the court of appeal, you were done. There was nothing else to do. But most states now use intermediate courts of appeal. So it's possible you go to the Court of Appeal, lose your appeal, and then go and petition for the Supreme Court to take it. And if they take it, then they could overturn what the Court of Appeal does. Okay. The number of judges in intermediate courts of appeal, Massachusetts, there's 28. Texas has 80. Let's see, New York, the appellate terms of the Supreme Court has 13. New Jersey, the appellate division of the Superior Court has 35 justices. So you can see that there's not a lot of justices there. This is actually a number of judges, but they hear a lot of cases. They hear every one of the appeals from every one of the trial courts, which can be a considerable number, especially in criminal cases. We don't see as many appeals in civil cases, but we do see a lot of appeals in criminal cases. Because they have a right to appeal, they might as well appeal it. The ones that don't get appealed are the ones that are guilty verdicts. Okay. Because if you plead guilty to something, you can't appeal it. If you agree to it, you can't appeal it. Let's see what California has here. It doesn't say how many in California here yet. Okay. I don't see it. All right. Let's keep on going here. Let's look at a thinking point here on intermediate courts. Why don't you research states that have intermediate courts of appeal, and then do you think every state should or should not have this type of court? Essentially, do you think we should have a Supreme Court that oversees the courts of appeal at an intermediate level? In essence, do you think we should have a Supreme Court to sort of take up matters that the courts of appeals have, let's say, split on? It's possible if you have more than one court of appeal making decisions, and each one has jurisdiction over a certain number of trial courts, it's possible, even in the same case, that they could disagree on how the law should be applied. And so in certain trial courts, the law is one way, and in other trial courts, it's another way within the same state. If you had a Supreme Court, though, they could break that tie and decide on what's the right way to do it so that all courts then have to follow it. What do you think about that? It's a good question to ask. All right, let's look at the state high courts of last resort. Texas and Oklahoma have 2 courts of last resort, one for civil cases, one for criminal. Not true in California. We only have 1 Supreme Court. So typically that's what you find. All the others have only 1 Supreme Court. Most states have a purely discretionary docket at the Supreme Court. There is an exception to that in California. If you have a death penalty case and you have a penalty of death that has been enacted at the trial court level, you have 1 right of appeal directly to the Supreme Court. You bypass the Court of Appeals altogether. They want it to be done quickly, and they want it to be done at the highest level because it's the highest crime and the highest penalty. Most states have, again, purely discretionary docket. That means that the Supreme Court only will allow cases that it agrees to hear, and not ones where they have to hear it. They don't employ panels as the intermediate courts do. So what's the impact on the death penalty, for instance, for this? Well, it means that in cases where there's not a direct appeal to the Supreme Court, which is true in California, then it could be that death penalty cases will only have 1 right of appeal, and that's at least one of the effects. States with an intermediate court of appeal, some have discretionary dockets and some have non-discretionary dockets. In California, they have a non-discretionary docket. That means that they have to hear an appeal from any trial court. Any trial court judgment that there is, civil or criminal, they must hear the appeal if there's an appeal filed. They have to hear it, and they have jurisdiction over it, and they must hear the case, and they must make a ruling. Not true in other cases. Let's look at the Supreme Court in California. Interestingly, they say there is 7 in our Supreme Court justices in our Court of Last Resort in California. Alabama has 9. You look at these numbers, every one of them is an odd number. The reason why is because they don't want to see a tie. That would make it very difficult for the court, and too many ties will make it so we don't have resolutions in the Supreme Court. We can't have that. So we do away with that by having an odd number of justices. Okay, let's look at the court reunification. Some of the key components of that are a unified court system itself is got a lot of advantages to it. First, you can standardize the way in which the clerks do their business, and all the forms that are used in the court system. They can make it so that if you could practice exactly the same way in a court, let's say in San Diego, California, as you could in Eureka, California, at the 2 extremes of the state, north and south. And that would be a nice thing to have. It has lots of advantages. The systems would be much more efficient because everyone could be trained on exactly the same system. You could keep things together and know how to run the system much easier, more efficiently, and so on. It simplifies the court structure itself because we have just, let's say, superior courts, then the Court of Appeals, and then the Superior Court, the Supreme Court, you just figure out which of these superior courts you go to based on the venue statutes. In essence, venue just simply says where it is that you will file in the state of California if the state of California has jurisdiction over your case, and then you file there. You have your resolution. You appeal if you want to, and then you're done basically. It also centralizes the administration, the rulemaking, the judicial budgeting all becomes centralized, so that, let's say we have one county that has 5 judges. Well, they're all going to get paid about the same amount of money, for instance, and you get the same quality of judges that are running for office there because it's the same amount of money. You have the same, pension system for the judges. The rules are standardized throughout the entire state, so all the courts will be under the same set of rules. And you have statewide financing so that we can sort of homogenize the spending, so that depending upon the number of cases that are filed, you get a certain number of dollars based on the number of cases you have to deal with, and so we can even out the spending in some fair and equitable way among all the different cases. All right, let's look at Ewing versus California. and this was a very interesting case. This was the first time the Supreme Court took a look at the three strikes law in California. Of course, California had the first of the three strikes law, and that three strikes law was a very, very strict law, to say the least. If you had a felony and you had at least 2 strikes in your background, strikes were certain types of serious or violent felonies, then you could go off to 25 years to life in prison. And you had to do 80% of your time at a minimum. So you're dealing with a sentence of at least 20 years and possibly for the rest of your life. Now, what this case was all about was Ewing had 2 strikes in his background. One of those strikes was a theft crime, probably a burglary. And burglary is being a theft crime. It happens to be in California that if you get a second theft crime after having a first theft crime, the second theft crime, even though a misdemeanor, like say petty theft, will be elevated to a felony. So what happened is Ewing actually went in and stole 3 golf clubs. He put them in his pants, of all things. Why he wanted 3 golf clubs, I don't know. Why he thought he could get away with it if he got caught, I don't know. He must not have known that the petty theft could be elevated to a felony. Anyway, he's prosecuted under the 3 strikes law for 25 to life. He's convicted. He's sentenced to 25 to life. They go to the Supreme Court of California. The Supreme Court of California says that is not, repeat, not cruel and unusual punishment for what happened here. He was warned if he had another felony, he would end up with 25 to life. He had another felony, so long, you're gone. Now, interesting that later on, some decade or 2 later, the public, through their initiative process, actually modified 3 strikes to not allow this to happen. Now you have to, your 3rd strike has to be a true strike. It can't be just a felony. So you have to have literally 3 strikes in order to get to 25 to life now. But back then you didn't. You only had to have a new felony and 2 strikes in your background. All right, so other states may have something less strict than that in their 3 strikes laws, but it was this was all a reaction to the 1980s when we had a very high increase of violent and serious felonies in the United States generally. And it was in the early 1990s that these things were passed in California in response to the very high crime rate, which has since died back significantly. Probably not because of 3 strikes, by the way. In any event, it was interesting to see when we had people with 1 strike in their background and they were subjected to doubling of their sentence and a minimum of 80% of the time. It was not unusual for people who had pled guilty to their crime to actually say that as soon as I'm out of prison, I'll be out of California. I will never come back. And that's because they don't want to be hit with some extreme penalties for what were maybe possibly small crimes. In any event, the question is, is this something so harsh that it would actually violate the cruel and unusual punishment aspect of the federal constitution or the state constitution? That's a difficult question. The court said no. People eventually said yes, and we wanted to change it. But what do you think about that? It's a good thing for you to think about. Is this too much for people who have had serious or violent felonies in their background? Okay, that's it for Chapter 3. And again, if you have any issues with the learning, please feel free to give me a call or email me, and I'll be more than glad to help you.